So I'll say at the outset, I'm not sure that you could derive every conclusion in this paper purely from the text of the Constitution and the founding era materials, even, the first couple decades of founding era practice, all of which I talk about in the paper. I do think everything I say in the paper about severability is consistent with those things and is the best set of inferences we can draw from the text of the Constitution and the history of the Constitution. So I think it is the best. I think you need to have a theory of severability to decide cases. I think this is the best theory of severability an originalist can have. But I'll admit right now, you're not going to find exactly the right proof text in the Constitutional Convention or anything like that. It is also a question that has heavily occupied some of the court's most originalist justices recently, Justice Gorsuch and Thomas especially, who in a number of the court's recent severability cases, ranging from the separation of powers to standing to free speech to federalism, have started to put forward some complaints about the way the court currently deals with severability, a suggestion that there is a way a formalist, originalist, textualist judge ought to be able to do it better. And it seemed to me they don't fully have their own principles worked out, and in the past couple of years have started to disagree amongst themselves repeatedly about what their supposedly shared principles require, which suggested that somebody needed to intervene. So this is my attempt. All right, so the current black letter law of severability, which we all will take as the enemy, says that when a part of a statute is unconstitutional, the courts have to engage in severability analysis to decide what part of the statute to strike down and what part of the statute to keep. And the presumption is severability. So the presumption is that you drop or strike down the invalid part and keep the rest. And then the presumption can be rebutted. And the presumption can be rebutted either by a kind of subjective analysis, asking whether it's evident that if Congress wouldn't have wanted that, wouldn't have wanted to keep the valid part without the invalid part, or maybe by an objective analysis that asks questions like, is what's left fully operational as law? Which sometimes kind of repeats the subjective analysis by just asking, does what's left operate in a way that the legislature would have wanted? And sometimes might be a more objective question, but either way, it's a presumption of severability followed by some ways to rebut the presumption. And this has produced a lot of doctrine that's not, grading on a curve. It's not totally incoherent. I think the court's kind of tried to work out some principles, but sometimes it does lead to dramatic and unpredictable conclusions, and it's caused some of the justices to rightly conclude that they may need a better explanation of what they're doing. I think that's especially true for those judges who also take a fairly textualist view and who would not otherwise be inclined to find statutory meaning in things like, what would Congress have wanted to do if it had addressed a problem that we know they didn't address? Kind of a method of interpretation by statutory intent that most textualists reject in the context of statutes. So there's a reason that a lot of judges are suspicious that this is the way they're supposed to solve this problem. So I do think we can do better. I think the first thing to recognize is a couple of basic principles. One, that severability is ultimately a question of law. So rather than thinking of the metaphor as a sort of remedy, the judge is faced with this constitutional wrong, an unconstitutional statute, and the judge is asked to apply one of his remedial toolkits, like severance, to the statute, to cut off the bad parts so what's left is okay. Rather than that metaphor, we should think about judges as just trying to figure out what the law is in light of a set of conflicting instructions, in light of a statute that says do X, and a constitutional provision that says don't do X, or at least don't do X sub 1, don't do X sub 2, don't do X some of the time. Judges just have to figure out what the law is in light of a conflict of materials. That should be a familiar metaphor and task, because that is how John Marshall talks about the task of judicial review in Marbury as a conflict of laws problem between the Constitution and lower law. John Marshall says correctly, I think, that the Constitution is supreme over lower law, so in that sense the conflict is easy, and the job of judges is to apply the law. So having concluded the Constitution is supreme over lower law, judges should apply the Constitution, not apply lower law. So far, so good. So then what happens when we try to apply these principles to severability, to statutes that contain, an unconstitutional part and a constitutional part, some good applications, some bad applications. Now I think we need two more principles. One is the principle that the Constitution displaces things that are unconstitutional. It stops them from operating. That's the kind of application of the Marbury principle. So as a principle of constitutional law, when you have a statute that has a bunch of applications, the Constitution just sits on top of it, stops the unconstitutional parts from doing anything in any particular case. That's principle one. Principle two is that there could also be statutory instructions about what to do in that circumstance. So Congress can enact what we now call fallback law, although I think that's a 20th century term, maybe even a 21st century term, not a founding era term. If somebody can find the founding era term for fallback law, I'd be much appreciative. But Congress can enact law that's contingent on unconstitutionality, that says, implicitly or explicitly, if part of this statute is not enforceable, this other part should not be enforced, should be enforced, you should do something else entirely, anything like that. So that's really a principle of statutory interpretation in a way, that you should look to the statute and see whether it gives any kind of instructions about what to do in case of unconstitutionality. So we have a constitutional principle of displacement. At the time, they often would have used the word repugnant. They'd say the Constitution displaces things that are repugnant to it, statutory rules or acts that are repugnant to it. And then we have a statutory interpretation principle that for anything else, for anything like what Congress would have wanted to do, you should look to sources of law. So you should look and see, has Congress actually enacted anything that tells us what to do? And indeed, I sometimes wonder if current severability doctrine actually grew out of these principles just in a very different era. So in the era when judges were willing to find essentially statutory meaning by looking to the hypothetical intent of Congress, they were willing to interpret a statute not in light of what it said, but in light of what they imagined Congress would have wanted to do had it been confronted with the problem, then maybe severability doctrine was just doing the same thing. It was the application of these principles in an era where they just, were very, very intentionalist. But as law has moved away from that kind of intentionalism everywhere else, it's time for severability to move away from it to the same degree. Or I guess we could resurrect it, and then this paper could be overtaken by those events. So either way, you'll still end up with those two basic principles. All right, now just a couple more things. How does this apply? In the ordinary severability case, again, I think this applies pretty straightforwardly, right? This gives you what we would describe in severability doctrine as kind of a rule of maximum severability. Every application of the statute is effectively severed from every other application of the statute because you just don't follow the statute in the cases where it is unconstitutional. But that's just a presumption that could be changed by Congress if it chose to. Congress could choose to yoke provisions of the statute together, to adapt an inseverability clause, to do more creative things that say about how we should group together different kinds of applications. So you get a rule of presumptive severability with the possibility that Congress can change it. How it applies to some of the cases the Supreme Court has confronted that have driven Justice Gorsuch and Justice Thomas to their views, I think can be more complicated, but I think a few of them we can say more about. So one is, what about standing? An issue that captured the Supreme Court, especially in the case of California versus Texas, where the argument by the state of Texas was that the unconstitutionality of one provision of the Affordable Care Act should be used to declare the entire Affordable Care Act unlawful. And one of the many challenges to that suit, in fact, the one that the court eventually used mostly, was to say there are various standing problems with that Texas is not really injured by the part of the statute they think is unconstitutional, and so how can they use that as an engine to bring down the whole statute? And one thing I think we can say from these principles is actually this part of Texas's theory was not wrong. Now, I don't think the Affordable Care Act is inseverable, so I think the theory is just wrong on its own terms about the severability of the Affordable Care Act, as I argue in the paper. But what Texas was trying to do, something my sometime co-author Steve Sachs has called bank shot severability, or bank shot standing, was to say, this provision of the statute injures us. It is attached to, it is inseverable from this other provision that's unconstitutional. Therefore, don't apply the statute to us. If inseverability works the way I say it does, that's just Congress saying these two provisions of the statute should stand or fall together, that's a perfectly valid legal argument. It's as if Congress has adopted a statute that says Texas is required to adopt the following regulations, asterisk, Texas is not required to adopt these regulations if the individual mandate is unconstitutional. The individual mandate is unconstitutional, therefore the asterisk applies, therefore the regulations don't apply. That's a perfectly valid legal argument if the provisions are indeed inseparable. And I think it's easier to see that once we see severability as law. Again, I think it fails for other reasons, but so be it. The other problem, which I don't claim to have entirely solved, although I do try to canvass all the solutions and basically grade them, is the problem of unconstitutional combinations. So what about when two provisions taken together create the constitutional problem, and either one of them standing alone would have been permissible? What do we do then? And here I think is just where it's easiest to see that the Constitution alone just doesn't tell us everything we need to know about severability. To borrow something that John Harrison told me, the Constitution is very good at telling us what the law is not. It is not always good at telling us what the law is. So the Constitution tells us the law is not the combination of A and B. It alone doesn't answer which of A and B are supposed to prevail. So the natural place to turn is to some kind of instructions from Congress or some kind of fallback law. In many cases, Congress won't have enacted one in the text. So if you're a pure textualist who thinks that's the only thing you can look for, that starts to look really embarrassing. At that point, the only real options to answer the question are to use a little bit of congressional intent, something that many textualists are willing to do in cases of ambiguity or silence where they need some kind of answer, to use some set of canons, and we could talk a little bit about what the severability canons are, where they come from. That's something some of the other justices have proposed. Another good tactic for textualists to deal with statutory ambiguity, or to basically try to find some way to give up. And it's not really clear what that would look like or how it would be defensible. So I think probably justices have to go with the first or the second, but the third may be tempting.